everybody.
Morning.
Thank you for indulging me in starting a little bit late. Had a bit of a child care issue, and but we will go today until my voice gives out, which may not be too long. Let's pick up where we left off last time, and I just want to recap the same transaction test for claim preclusion, because when you're working on a claim preclusion problem, these are probably the steps that you want to go through, okay? So make sure you're analyzing those three elements. Same facts, same parties, judgment on the merits, okay? And so picking up where we were on these problems, I think that we did not talk about problem number 2, right? We did number 1, but not number 2. So same facts as in problem 1. What are those facts? Well, this is the car wreck case. Okay? Plaintiff and defendant in a wreck. Plaintiff sues. Defendant wins. Okay? And we said the proper vehicle in case 2 for the defendant to get rid of the case is going to be a what? Motion for summary judgment. Say it loud and proud. Attach that prior judgment. Say, look at this. This already happened. Make it go away, Judge. The judge makes it go away. Hopefully, right? So, altering that hypo a little bit. Same thing, except plaintiff wins in the first trial. Ignore these 3 at the bottom first. Plaintiff wins. Plaintiff then says, I forgot to sue for damages to my actual car. Somewhat unrealistic. I can't imagine this ever happening in real life, but let's entertain it. I forgot to sue for damages in the first case to my actual car, so now I'm going to do that in case number 2. Is that okay? What would your gut tell you?
I'm still gonna say no.
What would your mother say?
Still no.
No. Can't do that. You already had your shot at it. How does this break down if we were going to analyze it under the elements that we had before? Okay, look at your elements. Same facts? Yes.
It's the exact same parties, because it's still
Same parties.
cause of damage to the car.
Same parties? Even if I go back and just sue, let's say, an insurance company, right? Still same parties, because those parties are going to be in privity. You sue an insurer for a party, you're essentially suing that party. Same parties. Judgment on the merits? Sure. Yeah? Everybody okay with that? That's not causing any confusion, right? If it is, let me know. Now, what if case 1, what if defendant gets a summary judgment on case 1? Can plaintiff, does that change anything? Can plaintiff then come back and say, all right, well, look, you got a summary judgment on this case for my personal injuries, but come on. We haven't litigated over the damage to my automobile. Is that still a judgment on the merits, a summary judgment? Oh, I got some mixed responses on that. Is a summary judgment going to be a judgment on the merits?
Yeah.
Yeah. Summary judgment, generally speaking, going to be a judgment on the merits. Be a judgment on the merits. You know, if the case gets dismissed, the first case gets dismissed for improper service of process, can the plaintiff turn around and file another case? Say, you know, I changed my mind. I don't want to litigate over personal injuries anymore. I wasn't hurt that bad. Just going to litigate the damage to my automobile. Is that okay, or barred by claim preclusion?
I have a question about the first one.
Okay.
If a motion for summary judgment was granted because the plaintiff did have the necessary facts to prove the case, but then they did get the facts, is that still precluded?
Yes. Yeah, because the summary judgment contemplates you've already had time for discovery and you've already had time to get those facts. You can't go running back to the courthouse and say, look, I've got new facts. There's devices for that.
What if they were outside of the complaint?
They were outside of the complaint.
The original complaint?
We're talking about stuff that's outside of the original complaint when we're talking about summary judgment anyway, aren't we? Right? Jessica?
Vernon Hopper's our process would be a different case, I think, because the case, there wasn't a judgment based on the merits, it was a procedural thing.
Yeah, that's right. That's the answer there. A judgment is not based on the merits. Did you hear? The case gets kicked out for improper service of process. That's not a judgment on the merits. So claim preclusion would not bar a second suit under those circumstances. That makes sense to everybody. The last one is the one that's really fun.
Trick question.
What if the plaintiff had obtained a default judgment against the defendant? The defendant decides, I'm not going to defend this lawsuit. Just get your default judgment. Plaintiff gets the default judgment and then says, well, that was easy. I'm going to turn around and file another lawsuit. Get another judgment. What do we think? Is that okay? What does your gut tell you about that? What happens if you apply our three-part test? Is it the same transaction? Same facts? Yes. Same parties? Yes. So we're left with asking, is that default judgment a judgment on the merits? The answer is usually yes. If I just decide not to answer, think about requests for admissions. Think about how we treat requests for admissions, just by way of analogy. If I decide not to answer those requests for admissions, what happens? You're deemed admitted, right? If I decide to just not answer a complaint, I'm going to be in default. And essentially, the court treats that as, all right, you concede everything that the plaintiff says in their complaint, resulting in a judgment on the merits. Are we good with that? Does that make sense? Okay. Court grants summary judgment to the defendant because the statute of limitations is blown. This is almost quasi-realistic, right? Because here in Kentucky, the general statute of limitations is 5 years. Over in Indiana, you get 2. Depending on what the cause of action is. So, and you saw in our example from last time, the 6-year statute of limitations under New York law versus the 3-year statute of limitations in Delaware law. Right? Remember what happened in that case? Keep that in the back of your brain as you try to answer this one. I bring a claim in Kentucky. No, better yet, I bring a claim in Indiana. The court says, no, this is barred by the statute of limitations. Kentucky, where the statute of limitations is more generous. Refile the damn thing. What do we think? What's the question you have to answer? We know it's same facts. We know it's same parties. Those are usually the easy ones. The question is going to be, was this a judgment on the merits? Was it a judgment on the merits? When you put it that way, it's like, what does your gut tell you about this one? Yeah.
Should have been in Kentucky all along.
Should have been in Kentucky all along. Gut tells you it's probably going to get kicked out on some grounds, but claim preclusion ain't it. Jessica?
But this is what is kind of tripping me up, is because the summary judgment is on the merits, but the statute of limitations, that's more of a procedural thing, so it's like, it's a mixture of both.
Yeah, in most jurisdictions, when you dig down into the case law, statute of limitations is considered to be a procedural matter. Right? That matters for Erie, and it matters here. Okay? Statute of limitations procedural. So think back to the news story that I gave you. We'll go all the way back to whatever slide that was. This guy here. Part of the rationale for applying the Delaware 3-year statute of limitations is because the court is saying, all right, even though you contracted for New York law to apply to this contract, even though your choice of law provision in that contract says New York law will apply, we're going to construe that to mean substantive law. And you didn't specifically say New York procedural law applies here, and the statute of limitations is procedural. Ergo, we're going to apply the law, the procedural law of the forum state, which is Delaware. Make sense? Isn't this fun? Questions about any of that before we move on to the issue? All right. Here are the elements, somewhat different.
Right, that's again.
Yes?
Sorry, can we just say what the conclusion was real quick? Because we said it wasn't gonna be under claim preclusion, but is it, Neil and I were wondering if it was constitutional, like.
Yeah, what ultimately happens in that
Yeah.
case?
Yeah, just with the statute of limitations, like, sorry.
No, it's all right. The question that I have, and the hypothetical doesn't give it to you, the question is, what sort of claim could you do that with without it getting kicked out for a proper venue or something like that? So, I think we have to live with the hypos we have. Assuming that there is such a creature that you could bring properly in both states. But I think that's a big assumption. There's a lot of hurdles to being able to get there. The answer is it's not barred by claim preclusion. You could, in fact, without being barred by claim preclusion, bring it in the second state. That doesn't mean there's not going to be some other bar to bring it to suit. And my instinct is that the court would probably try to figure out a way to get rid of it.
Thanks.
Yeah. All right. So your elements here, actually litigated, actually decided by the court. A ruling on the issue must have been necessary to the judgment. You can kind of skip the middle two elements. But if the ruling on the issue was necessary to the judgment, it was probably actually litigated and probably actually decided by the court. Those two middle elements are kind of goofy. but that's the majesty of the law. Same issue, we're talking about issues, not necessarily a nucleus of facts. Actually litigated, right, is different from a judgment on the merits too. We'll see how that works. Let's talk about Williams. If I can figure out what page it's on. I like the reading for today because it's all 1983 cases. It's all cop cases. So what happens in this case? Plaintiff files a lawsuit under 1983 for constitutional torts. Remember, that's the vehicle for getting the constitutional torts into the federal courts, which you'll see when you take my civil rights class. Constitutional torts, but then they also pile on all these other state law causes of action. Same set of facts, just different claims. They file this case in the state court, and then what happens? What's the first thing that happens when they file that case in the state court? What does the defendant do? What would you do? Sorry? By the way, do you have to file a motion for it to be removed to the district court? Did you guys cover this last semester? No. Is removal something that is a matter of discretion or a matter of right? Removal jurisdiction? Yeah, matter of right. Matter of right. You just simply file a notice of removal as the defendant. File a notice of removal, refile the case in federal court, defendant pays the filing fee, we go on. So, defendant decides, no, I don't want to litigate this in state court. We're going to litigate this in federal court, which always, you'll hear from a defense attorney next week, always happens in this kind of case. Get removed to federal court, and the federal court exercises supplemental jurisdiction, or pendant, with an E, not pendant, unless you're into jewelry litigation. Pendant jurisdiction over the state law claims. Super common in this kind of case. What's the district court do with the case? Give it to me in a nutshell. The federal district court does what with the excessive force case? Well, give me a little more than that.
They say that the federal claims aren't liable, but they don't talk about the state claims.
The federal claims, the court dismisses. Is it a dismissal on the merits? The constitutional claims, are they dismissed by the federal courts on the merits? Yes. Okay. What happens to the state claims? This is the important part. It's right up front in the case. This is the important part of the case. What happens to those state claims? Dismissed without prejudice because what?
So that they decline to exercise supplemental jurisdiction.
They don't want to exercise supplemental jurisdiction, right? court says, we've determined all the federal claims in this case, and now we could exercise jurisdiction over these state law claims, but we don't want. Right? In most states, there's a saving statute. Probably all states, I don't know. There's a saving statute for cases that get booted out of the federal court. In Kentucky, you'd have 90 days to refile your claims without worrying about the statute of limitations. And in fact, that's what the plaintiff does here. Right? Those claims, the state law claims, have been dismissed without prejudice. Was that a dismissal on the merits? The state law claims. State law claims dismissed on the merits? No. Dismissed without prejudice just because the court didn't want to exercise jurisdiction over them. Plaintiff refiles North Carolina State Court, where the plaintiff had filed to begin with. And what does the North Carolina trial court do with it? Give me that in a nutshell. Come on, folks. I know we're getting down to the wire here, but what does the North Carolina trial court do with this case? Deny a motion for summary judgment by the defendant. Defendant says, you should toss out these claims. What's the defendant's argument? There's two of them. The things that we've been studying in class the last two rounds. Client preclusion and issue preclusion. Trial court says no, summary judgment motion denied. Why, then, are we reading an opinion from the appellate court? What? I can't hear.
Sorry, the defendant's appeal.
The defendant's appealed, but is there a final judgment? The court said no, you can keep going.
Is that how you pronounce it?
What? Certiorari has nothing to do with it.
No, that's what he said.
No, don't say that.
Say that.
No one should be saying that. It is too early in the morning to be talking about certiorari. What do you think? How can they get to the appellate court? How do we have this opinion if the trial court says, no, you lose on summary judgment? Philip?
Interlocutory.
It's an interlocutory appeal based upon what, do you think? Doesn't say any place in your materials. There's no reason you should know. I'm just seeing if you know. Police officers and other state actors enjoy something that the rest of us don't get. Actually, I might get it because I'm a state employee. Immunity. Immunity. Yeah. Immunity gives you the ability, qualified immunity gives you the ability to go running to the appeals court, even if you don't have a final judgment. If the judge says, no, I'm not going to grant summary judgment in your favor, you have the right in most states and at the federal level to an immediate appeal of that decision. That can then tie up the case for another 2 years. Lots of fun. What does the appellate court say? In a nutshell, what does the appellate court say? Short form verdict. Who wins? For the love of God, who wins the case? What? The plaintiff wins the case on appeal? Did you read the case? But that only leaves us with one option. It's a cop case. The defendants always win. Defendants always win. But why? Why do they win? Let's talk about why claim preclusion doesn't apply. The court does say, no, we're not going to apply claim preclusion here. Why? We've already covered it. There was a final judgment. There's no judgment on the merits. That's it. That's it. No judgment on the merits for the state law claims. Okay? There's a judgment on the merits for the constitutional stuff. That's over here. No judgment on the merits on the state law claims. The court just said, we don't want to deal with that. You take it, state court. Take the ball. State court looks at it and says, yeah, okay, well, we can't throw it out on claim preclusion. But instead, we'd really like to get rid of this case, and so what are we going to do with it? Neil?
So, they said that it was issue precluded or collateral estoppel on the issues regarding the reasonableness of Officer Houston and Burkhardt's actions because they were already litigated in the earlier suit. The issues were actually raised and adjudicated in the earlier case, in case 1. They involved the same parties in case 1 and in case 2. And that issue was essential to the resulting judgment in case 1 on reasonableness.
Is this the same issue? The court seems to think it is. I'm a cynical plaintiff's lawyer. The court says the federal court already ruled on summary judgment that the officer's actions were reasonable under the Constitution. The court didn't rule on all these state law issues, but close enough. Close enough. Saying that the officer's actions were reasonable is kind of like saying they weren't negligent. And so they get rid of it. The lesson here is the court is going to get rid of the case if the court wants to get rid of the case. The court doesn't like the case. Note 4 on page 679. Just a quick note on this. Because it might be a fun intellectual exercise, but it's outrageously unrealistic. Plaintiff sues the defendant based on an auto accident. Then the defendant, after a judgment is entered against the defendant turns around and sues the plaintiff for damages sustained in the same accident. I say all that to say that is goofy, right? In most jurisdictions, you're going to have a rule that requires you to file a counterclaim against the plaintiff if you're the defendant in this scenario, okay? You're going to have to, or you're going to be forever barred from bringing that claim ever again. More about that later. The chances of something like this happening in the real world are effectively zero. Effectively zero. The defendant would have to counterclaim in that original suit, or else they're not going to have the opportunity to do it. Just want you guys to know. All right. Now this one, on the other hand, number 5 on 679. This is dealt with in the problems too. Criminal case. Criminal defendant stabs victim, is convicted of felony assault. Victim then turns around and files a civil lawsuit. Victim becomes plaintiff. Files a civil lawsuit against the criminal defendant, who's now a civil defendant. Let's think about that. Let's think about how that plays out, because I have litigated this several times, and you might end up litigating it too. O.J. Simpson. We'll get there. We're not at O.J. yet. O.J. is example 2. Example 1. Somebody's found guilty. Right? And then, what does that do for you? You're the victim. What does that do for you? Does that put money in your pocket? No.
Just gets them off the street.
Maybe it gets him off the street. Maybe. I want compensation. So I turn around, sue criminal defendant who's already been convicted. If you're the plaintiff in that scenario, the plaintiff, what do? You file that lawsuit, and then what? Allison.
So I might not be following you, but so it was originally filed in criminal court, you can still let OJ sue in civil court for like personal injury.
Yes. Yeah. Everybody get that? We're okay with that, right? There's a criminal conviction, that's over here. That's on Planet Criminal. We're not talking about that. We're here in civil procedure. Assume the civil law lets me file a common law suit for battery, just like the kind of suit that we've been talking about all semester long. So I file against the criminal defendant for battery. That's my civil claim. What do you do if you're the plaintiff? Somebody had a hand up. Yeah, Jessica.
I was going to say that it says it involves the same issue. In a sense, it doesn't. The elements for a criminal assault are different from the elements of a civil assault. So there, in a civil context, there is a question of whether you commit the assault, isn't there?
Are we talking about elements, or are we talking about issues?
The question is whether you committed the assault. If the definitions in the two courts are different, then doesn't that have an impact?
I think that what we're talking about there is so entirely unlikely that it's probably not. Certainly not something that was contemplated by the writer of this hypothetical. Would you expect that the standard for proving civil assault would be lower or higher than the standard for proving criminal assault? If they can prove criminal assault, what's the standard? What's the standard of proof for proving that he was criminally liable for assault? Good. You can skip criminal procedure. Beyond a reasonable doubt. What's going to be the standard of proof here? Most likely. All right, so the evidence. So if he's definitely done a criminal assault, and I think, Jessica, your question is it possible for civil assault and criminal assault to be so different that they're not considered the same issue? I think that's extremely unlikely. Extremely unlikely. I guess anything's possible. Right? So back to my original question, though. You're the plaintiff. What do you do? How do you avoid going to trial on this case? Okay. Assuming you don't settle. Assuming you don't settle because this criminal defendant doesn't have a pot to piss in, which is usually the case, right?
Sorry, I can't.
And false flag. Kelsey?
File a summary judgment and attach the criminal.
File a summary judgment. File a summary judgment. win? Oh yeah, you should win. Standard of proof is much lower. He's already been convicted by another court. This is classic issue preclusion. Right? Turn that on its head. He's acquitted by the criminal court. The stabber is acquitted. Not guilty. Is the victim going to be precluded from bringing a lawsuit against the attacker? No, everybody's saying no. We know that because O.J. Simpson. But why not really? Why not really? That's it, yeah, yeah. The standard of proof is much, much lower. Much, much lower. The issue in case one is beyond a reasonable doubt did he do the stabbing. The issue in case two is by a preponderance of the evidence did he do the stabbing. Yeah. So plaintiff can still litigate that case. Does plaintiff get to file a motion for summary judgment right off the bat? In case two, of course not. Of course not. Have to prove it. Have to prove it. Incidentally, in this first situation, there's been a judgment on the merits in the criminal case, right? There's been a judgment on the merits. Why isn't the victim barred from bringing that case by the doctrine of claim preclusion? Something that your book doesn't answer. Think back to your elements of claim preclusion. What are they? Yeah, Allison.
There's no judgment on that.
I just said there was a judgment on the merits. Yeah. There was a judgment on the merits, right? It's a criminal conviction. That's a big judgment on the merits.
It's not the same parties as the state.
It's not the same party. That's right. That's right. It's not the same party. Victim wasn't a party to the original case. Make sense? Keep going. When you ask if something is actually litigated, I mean, you're gonna know that, right? Just as with your claim preclusion type situations, sort of technical dismissals for improper service process or whatever, that's not gonna work. Right? Keep going. Was it actually decided by the court? It was actually decided, chances are it was actually litigated. Really just asking if the court made a decision on the specific issue that you think has a conclusive effect. Necessary to the judgment, now that's the big one. And I can't think of a situation in which something was necessary to the judgment, but it wasn't actually litigated. It wasn't actually decided by the court. Maybe there is such a thing. Always willing to be proved wrong, but I can't think of one. Let's talk about Stemler. Another cop case. Right here in Florence, Kentucky. Well, not right here, but right up the road. Again, involving two separate cases. This case is kind of the opposite side of the coin of the other case that we read. So what happens here, because we don't have time to parse it all out, what happens here is there's a wrongful death action filed in the state court. Contemporaneously there is a constitutional action and a 1983 action filed in the federal court. Okay? Why does that happen? I'm not sure. And in case one, there's a wrongful death action. What does she have to prove in the wrongful death action? What does the plaintiff have to prove? What does her estate have to prove? She's dead. What?
Somebody died.
Somebody died, yes. That is an essential element.
Wrongfully.
What do we think? Did you guys read this case? Maybe. What does she have to prove for wrongful death? Be prepared for vigorous questions about this on the final if you don't give me an answer to that. Go ahead, Ryan.
The victim must have been in state custody or otherwise restrained by the state at the time of injury, and the violence must have been committed by a state actor. That's the right one.
Kind of. What's the difference between what she's got to prove in the federal court and in the state court? This one is a thorny procedural thing because the plaintiff decided to file in two different jurisdictions at the same time. And I think the case is super confusing. Well, it's probably super confusing to you folks, or to anybody who's never litigated a cop case before. There's different standards of proof for the wrongful death action on the one hand and the constitutional action on the other hand. It's a lot like Williams, where in Williams you've got state law claims and federal claims that coexist in the same case. Okay? Here, you've got it in two different cases. So you end up with the absurd reality of state courts and federal courts coming to different factual conclusions. Police officers, is it sheriff's deputies? Anyway, police officers, law enforcement officers, pour her into this vehicle, and she subsequently wrecks and dies. And in the state court litigation, they say, well, she was never in custody. Okay? She was never in custody. And she had to be in custody at the time she was killed for wrongful death to apply. There has to be a special relationship for police officers to be liable in this situation. There has to be a special relationship, meaning they had to have her in custody at the time she died. That's the state court claim. Right? The federal court claim is the mechanics of this, the substantive due process claim, the 14th Amendment claim. She had to be in custody at some point in time. And the police officers had to have created the danger in some way, put her at an unreasonable risk of danger. So in case one, she would have had to have been in custody all the time, and the court says she was never in custody. And in case two, the federal court says, yeah, she was in custody at some point in time, but not the whole time. Right? If she was in fact never in custody, she was never in police custody, ever, as the Supreme Court of Kentucky says, and they don't owe her a duty for purposes of wrongful death or for the 14th Amendment. But the wrinkle is that the federal court says that she was in custody, however briefly, and so she can litigate the 14th Amendment claim, even though the Supreme Court of Kentucky said she was never in custody. Right? There's the language from the Supreme Court of Kentucky. She had to have been restrained by the state at the time the injury-producing act occurred. So she wasn't, so therefore, kick the case out. She gets nothing, she can't recover for wrongful death. It's not as against those defendants. Federal court says, but she was in custody for a minute, and that's enough to create a question under the state created danger theory. And so what the Supreme Court of Kentucky said when they said she was never in custody, that's just dicta. That's not part of their holding. It's just dicta. Remember in your first year class covering the difference between holding and dicta. I suspect that all of you did, even if you don't remember it. I know if you were in my class, we did. If you don't remember, I don't want to hear about it. Make sure you know the difference between holding and dicta, because that's the really important stuff when you're dealing with these kinds of problems. In Stemler, they say that the Supreme Court of Kentucky is saying, the Supreme Court of Kentucky saying that she was never in custody, that's just dicta. And why? Because it didn't matter to their judgment ultimately. What mattered to them was that she wasn't in custody at the time the wreck happened. So if, for 14th Amendment purposes, she had to be in custody at the time the wreck happened, then issue preclusion might be a thing. But she didn't. All the 14th Amendment requires is for police officers to have had her in custody at some period in time and set motions and events, and set events in motion. That was close. Set events in motion that led to her death. Worry about the exceptions to issue. All right, problems. Questions about Stemler? Are you okay with that? That's a confusing case. Yeah.
Is it kind of like the scope for the 14th Amendment claim is bigger than the scope for the state claim? So like if they don't line up, then the issue hasn't been decided. Is that like a fair way of thinking about it?
Yeah, kind of. Yeah, it's it's different in the sense that the state law is more demanding.
Yeah.
Okay? I mean, actually, the federal law is extremely demanding, but the state law on wrongful death, as applied to state actors, is in some ways more demanding because she would have had to, at least the way they construe it in this case, she would have had to have been in custody the whole time. And under the 14th Amendment, it just requires that basically just requires the officers to have created the danger for her in some way. Okay. So it is subtly different. And I think this is the rare occasion in which you see a judge go out of their way to make sure the plaintiff's claim is preserved. Yeah.
I do think I get it, but can we do like another, because it is kind of confusing.
typo of what?
Similar. If that's like.
You don't like the problems that are in your book?
Well, like, but that one doesn't have a different lump sum. Right? Or is it?
It's not the same claims. Like, what do you mean? Are you wanting to flesh out more of the difference between wrongful death and
No,
14th
the-
Amendment, or?
I guess the whole point of the reason why it wasn't included from the federal versus the state's holding was because the state's holding was all about dicta, so you're still able to bring.
Right, and in terms of the elements that we talked about for issue preclusion, what is the element that's lacking? Let's go back. Same issue in case 1 and case 2? Yeah, kind of. Was it actually litigated? Yeah. Was it actually decided by the court? Kind of, right? The court actually did decide. And she was never in custody. The Supreme Court of Kentucky said she was never in custody. But was that ruling on the issue necessary to the judgment? Federal court says no. Federal court says it wasn't necessary to the judgment. They didn't have to determine whether she was ever in custody. They just did. That makes it dicta, not the whole. According to Judge Boss. Your mileage may vary. This is a lot of hair splitting about the Sixth Circuit. Some of these problems, maybe we can get to them. Probably not. Products liability case. Okay. Plaintiff wins at trial. So you've done products liability, you do products liability and torts, right? So we kind of have a general idea. Products again injures because the plaintiff was still using the same product, get injured by that same product again, plaintiff sues again. First of all, you see why this is not a claim preclusion sort of thing. Right? Not the same transaction. Right? Different injury, different occurrence. So let's get beyond that. What are the issues that are precluded, that the defendant is going to be precluded from litigating, or either party, I guess, is going to be precluded from litigating in case number 2? And this involves a lot of it depends type answers. I get injured by one of these markers, file suit, get a judgment. 6 months later, I'm again injured by one of these markers, file suit. Do I have to prove that the product was defective again? Marker is a really bad example. But let's say that there's so much chemical juice in the marker that I become high from the noxious fumes it produces. And that's a defective product in case number 1. I win that. But then in case number 2, what actually happened was I was writing up on the board and a piece of the marker flew off and put my eye out. Issue preclusion? What's your gut tell you? None. Product is defective in a different way. Now, if you're saying the product was defective in the same way, issue preclusion? Probably. Yes. Why would you have to relitigate Court's already determined the thing is defective. No reason to relitigate that one. Whether I suffered an injury is going to be new every single time, right? Presumably. I wouldn't file another lawsuit if I hadn't suffered a new injury. Probably going to have to litigate that one. I don't get to go running to the court and say, well, since I was injured the last time, I'm also injured this time, and you should just give me the same amount of damages. Probably not. Assumption of risk is the fun. For the court? Yeah.
Sorry, can we use like another example, like Toyota Takata airbags?
You guys don't like my examples.
Well, like, because you're assuming the risk when you like pick up another expo marker, knowing that you were just injured by it. But
Do I?
You keep buying.
Okay, they fixed it. They fixed the fumes.
Oh.
Right. So,
I don't agree that you're assuming the risk.
yeah. Second.
I don't think you are assuming the risk because you don't assume it's gonna fall apart and go in your eye.
Are
Like,
you using the same one?
yeah, it is the same exact one. Yeah.
Like I said, the answer is it depends on a lot of things. All right, we'll go on with your airbag example.
So yeah,
Go ahead.
you keep buying Toyotas,
Yeah.
you keep getting in wrecks,
Yeah.
shrapnel from the airbag keeps hitting you. So, yeah, so there you don't assume the risk, right? It's like, oh, well, I'm gonna buy one that's not under recall, and oh, man, it happens again.
Well, but yeah, that is a different product. I think we could assume that that's a different product, or at least that's what I would argue if I was on the other side. So let's put it out. It's a different product. Right. Assumption of risk if you're using the same product, right? The same defect, right? Case 1 and case 2. Distinct injury, which I think it would have to be. But if I've got the same defect in the same product, and the jury says in case 1 that I didn't assume the risk, does that change in case 2? After I've used the same product again? Assuming I've been injured in a similar way? Yeah, maybe, right? It's just fun to think about. There's no answer. Yeah?
That's kind of what's throwing me off is that whether you're using the risk is like in the second suit, it's like you proved the point that you made in the first one. So I'm kind of confused.
Say that again. What's your confusion? You've proved that a product was defective in a certain way, right? I mean, I think the answer to all of these questions is it depends, right? So if you've proved that the product was defective in a certain way in case 1, you shouldn't have to prove that again in case number 2. That's not to say that if the jury decided that you hadn't assumed the risk the first time around, and then you go back to doing the same dumb thing with that product and get injured in a similar way, have you then assumed the risk the second time around? Well, maybe. Seems a little more likely that that's not going to be an issue conclusion type thing. All right, get out of here.